All right, I think we can get going. All right, we're gonna get started now, interpreters. So please be ready. Thank you.
Okay. Yep. Good morning and welcome. I am Rebecca Tepper, Secretary of the Executive Office of Energy and Environmental Affairs and the Chair of the Energy Facility Siting Board. Before we get started, I'll ask the interpreters to provide instructions for the interpretation services.
Thank you. Language announcement is now going to begin. We are providing interpretation services for this meeting in Spanish, Portuguese, Chinese, Vietnamese, and Haitian Creole, as well as American Sign Language. If you are in the hearing room, you can access interpretation using a headphone set available at the side of the room. For those on Zoom, you will see a globe icon button that says Interpretation. Click the globe and select your preferred language, including English. For Spanish, please.
Buenos días. Para esta reunión ofrecemos servicios de interpretación en español, portugués, mandarín, vietnamita, criollo haitiano y lengua de señas americana. Si se encuentra en la sala de audiencias, puede acceder a la interpretación usando los auriculares disponibles a un lado de la sala. Si está utilizando el Zoom, verá un botón con el icono de un globo terráqueo que dice Interpretación. Haga clic en el globo y seleccione su idioma de preferencia, incluso si es inglés. Gracias.
For Portuguese, please.
Estamos oferecendo serviços de interpretação para esta reunião em espanhol, português, chinês, vietnamita e crioulo haitiano, além da língua de sinais americana ASL. Se você estiver na sala de reuniões, poderá acessar a interpretação utilizando os fones de ouvido disponíveis na lateral da sala. Para quem está no Zoom, haverá um ícone de globo escrito Interpretação. Clique no globo e selecione o idioma de sua preferência, inclusive o inglês. Obrigada, thank you.
For Mandarin Chinese, please.
我们为本次会议提供西班牙语、葡萄牙语、中文、越南语、海地克里奥尔语以及美国手语的口译服务。如果您在现场参加会议，可以使用房间侧边提供的耳机设备收听口译。通过 Zoom 参加会议的与会者会看到一个写有 Interpretation 的地球图標按钮，点击该图標按钮，并选择您偏好的语言即可。谢谢。
For Vietnamese, please.
Chúng tôi cung cấp dịch vụ phiên dịch cho cuộc họp này bằng tiếng Tây Ban Nha, tiếng Bồ Đào Nha, tiếng Trung, tiếng Việt Nam, tiếng Creole Haiti cũng như ngôn ngữ ký hiệu Mỹ ASL. Nếu quý vị đang ở trong phòng họp, quý vị có thể sử dụng phiên dịch qua bộ tai nghe có sẵn ở hông phòng. Đối với những người tham gia qua chương trình Zoom, quý vị sẽ thấy nút biểu tượng quả địa cầu có chữ Interpretation. Hãy nhấn vào quả địa cầu và chọn ngôn ngữ quý vị muốn bao gồm cả tiếng Anh. Xin cảm ơn.
And for Haitian Creole, please.
Bonjour tout le monde. Jeudi, nous avons un service d'interprétation qui est disponible dans la langue que je vais mentionner, qui c'est espagnol, portugais, chinois, vietnamien, créole haïtien et puis tout langue américain. C'est aussi un monde qui ici là dans la salle là, dans l'audience là, ou avez accès ensemble avec service interprétation nous offrir. Là où utiliser casse là ensemble avec écouteur qui est disponible sous table là. Et pour ceux-là qui sous Zoom, yo, t'en prie, il y a un moment où après sous Zoom, vous pouvez remarquer il y a un bouton icône globe qui dit interprétation. Vous cliquez sur globe là, après ça, vous choisir langue préférée là qui c'est créole haïtien, ou capable de choisir anglais tout si vous voulez. Merci à tout le monde.
Thank you. Language announcement completed.
Okay, we're turning it on right now.
Okay, great. Again, welcome everyone. This is a hybrid meeting of the Energy Facility Siting Board taking place at the offices of the Department of Public Utilities, 1 South Station, Boston, and on Zoom. The hybrid meeting is intended to allow everyone to see and hear all speakers here or on Zoom. This meeting is being recorded and will be available on the Siting Board's YouTube channel. For remote attendees, if you are having difficulty with Zoom, please call or text 857-200-0065 for assistance. With me today are the members of the Siting Board, Jeremy McDermott, is also online. With me also is Andy Green, the director of the siting board. He will be serving as the Zoom meeting host. We have one item on the agenda for today, consideration of a tentative decision in EFSB 2510 regarding final regulations for 980 CMR 17.00 constructive approval. The constructive approval regulations implement portions of the 2024 Climate Act signed into law by Governor Healy on November 2024. The 2024 Climate Act makes fundamental changes and improvements in the way that clean energy facilities will be sited and permitted in Massachusetts. The siting board is required to promulgate regulations and guidance to implement these reforms for projects filed with the siting board starting on July 1, 2026. As we will hear from staff, the constructive approval regulation is designed to ensure that statutory deadlines are met and that necessary conditions accompany any such approvals through this mechanism. Goes without saying, but the constructive approval is not how the siting board expects its statutory review functions to be conducted in normal practice. Fully adjudicated decisions within applicable timelines define the siting board's expectations and objectives for the new process. Today's meeting follows earlier action by the board that opened rulemaking in EFSB 2510 for regulations required by the 2024 Climate Act. Other than today's topic of constructive approval, we have completed all the other siting and permitting regulations to be promulgated by the board per the Climate Act. The siting board will be voting on the final constructive approval regulations at this meeting. Prior to beginning our deliberations and voting, we will listen to those who wish to comment as time permits. The siting board has received oral and written comments on the constructive approval regulations throughout the lengthy rulemaking process, which have been posted on the EFSB DPU file room. Based on the input from siting board members, comments from agencies and the public, and further review, the siting board staff will be presenting today on the proposed final regulations for constructive approval. The siting board, the siting board provide notice of today's meeting to the Commission on the Energy Infrastructure Siting and Permitting, a broad group of stakeholders and member organizations, the Siting Practitioners Advisory Group, and the Interagency Task Force for Siting and Permitting. The notice was also posted on the siting board's website and provided under the Massachusetts Open Meeting Law. So we're going to have a quick presentation from the staff on the final regulations. Ms. Evans.
Thank you, Chair Tepper and members of the siting board. My name is Joan Foster Evans, and I am the General Counsel of the Energy Facilities Siting Boards, and I am presenting on the final regulations for constructive approval provisions of the 2024 Climate Act. As you noted, this is the last regulation promulgated by the siting board to implement the siting and permitting provisions of the 24 Act. After the act was signed in November of 2024, the siting board conducted an extensive rulemaking process, informal rulemaking process, to develop the proposed regulations. We conducted 4 public stakeholder meetings and a board meeting on our STAR proposals. Then we opened the formal rulemaking in September of 2025. Since then, the siting board has conducted 6 public comment hearings, a webinar, countless stakeholder sessions with state agencies, developers, municipal representatives, community groups, and others. The siting board has received almost 900 comments during this rulemaking process. Over the last 8 months, the siting board has issued 5 decisions and conducted 7 board meetings on the rulemakings. In those 8 months, the siting board has promulgated 2 sets of revised regs, 5 new chapters of regulations, and repealed 5 chapters of unused regulations. This is in addition to the meetings and the documents and the decisions issued by the Department of Public Utilities, the Department of Energy Resources, EEA, and OEJE. We want to thank everyone who has participated in this long process. and participated in these rulemakings. Everyone's input really improved the product that we have here before you. So just a short bit of context. As we know, the constructive approval provision establishes mandatory deadlines for the siting board to act. And if the siting board doesn't act within those mandatory deadlines, a project application is constructively approved. So there's 3 provisions that play into this. First, the board establishes standard permits, conditions, and requirements. That's what the act says. The act also uses the term common conditions and requirements in a couple of other places. We have construed the act as that is the same thing. So we're treating those 2 different ways of looking at this the same way. I will note that the common conditions and requirements, there's still some work being done by staff on those right now. Secondly, the board establishes deadlines depending on the size of a project. Large projects are 15 months, small projects are 12 months. The clock starts running when the siting board receives a complete application. And that's an important point. Lastly, the act defines what happens with a constructive approval and states that if the board misses its deadline, the board shall issue a permit granting approval to construct that includes common conditions and requirements. It is this last provision that these regulations seek to implement and give some substance to. So I want to talk about how we got to where we are, because there were several major changes made to these regulations over the rulemaking process. We took some extra steps as this was a new mechanism for the board, and it took a little while to figure out how to implement this mechanism. We issued a proposed regulation in September of 2025, and it contained 3 basic provisions. At about 60 days before the deadline, the presiding officer determines whether or not the siting board is going to make it to the deadline, and if there is not a good assurance that the siting board will be able to issue a final decision, the presiding officer issues a notice of likelihood of constructive approval. So that keys off the constructive approval process. There's a provision that allowed a draft constructive approval. In the initial regulations, those were done by the presiding officer with an opportunity for comments and modifications. And then finally, the issuance of the final constructive approval, which happens automatically and is deemed to be a final decision. So we issued those again in September of 2025, and we received a lot of comments. And during the comment period, there was much focus on the conditions that apply in a constructive approval. The September proposed regulation provided that common conditions and requirements would apply with really no further language. We assume generally that the generic conditions would apply in a constructive approval. We heard during the comment period multiple comments on this provision, especially that particular part of the provision, and especially from other agencies who were considering at the time how the common conditions and requirements could reflect the substantive laws that the siting board would need to follow when issuing a consolidated permit for another agency. Looking at the various comments, we realized that maybe a better mechanism needed to be developed rather than just simply relying on generic common conditions without anything further. So siting board staff went back to the drawing board and developed a new proposal that we issued in January of 2026. So the new proposal tried to address 2 main concerns. First, that the constructive approval reflect revisions to the project that occurred during the review process. And that's a normal part of our review process. Projects do develop and change slightly during the process. And secondly, concerns regarding applicable conditions. So staff drafted a proposal built on the procedural tools that we had already developed in the consolidated permit proceedings, mainly the condition conference and the presiding officer recommended permit conditions and requirements to establish conditions. By allowing the presiding officer to draft the constructive approval and include these recommended permit conditions, These provisions allowed the permit conditions to reflect the evidentiary record developed over months of adjudication and also the recommendations of the parties and the permit enforcement agencies. And we also included in that proposal in January a step to allow the board to vote on those recommended permit conditions and requirements on a consent agenda. Once again, we heard lots of comments, including some discussion from the board, both in the January 7th board meeting and the February 26th board meeting. So we had lots of discussion on that. There was a concern, especially with the vote, the board vote mechanism that we had included in that proposal. So the staff went back to the drawing board again and tried it again. So while we were looking at trying to figure out how to make this mechanism work, we did receive a proposal from Eversource and National Grid in March. And their proposal used much of what was in the January proposal. They used the presiding officer recommended permit conditions as a starting point to develop conditions for a project during a constructive approval. They recommended, however, that the applicant develop and draft the constructive approval and modify it within certain limitations. So staff looked at this proposal and issued it for public comment. So we issued it with a modified version of that proposal, and we called them option A and option B. So the staff modified version was option A. The straight company proposal was option B, and we issued that out for comment. We received a few comments, some of them in support of the staff proposal, some in opposition. Ultimately, staff included option A in the final regulations with a few changes. And there are other changes included in the regulations, and the tentative decision goes through all of those changes in more detail. So I'd like to note that the final regulations that you have before you reflects a balancing of the applicant's need for finality of board decisions with a need for permits issued in constructive approval to comply with requirements of underlying law and provide appropriate protections. We tried to balance that with the new the final proposal that's in front of you. Staff recognize that it is imperative for the board to complete review within the statutory timeframe in a timely and efficient manner. We are hoping that these regulations, even with all the development we've had of them, are used very rarely, but we think it's important to have a very clear process in the event that a constructive approval does occur. I want to note two other items on the final regulations. First, the final regulations include the option A, as I said before, staff proposal, and whereas the conditions developed during the evidentiary proceeding and the conditions recommended by the presiding officer are included in the constructive approval. I would like to note that those conditions are in part based on the common conditions that will be established by the board, that the board is still working on. And those common conditions show up in the proceeding in a couple of different places. They show up when the applicant works in pre-filing with the agencies and show up in the applicant's application and may be modified during the completeness determination that first month during the proceeding. They also show up in the statement of recommended permit conditions that the parties and the permit enforcement agencies provide during the process. And of course, they show up again during the conditions conference and the presiding officer's recommended permit conditions. So those common conditions and requirements show up in multiple places in the proceeding and end up into the constructive approval. I also would like to note that the final regulations contain two new fail-safe provisions that were not in the regulations, the proposals before. One, that they add a provision for the presiding officer to accelerate the conditions conference if a proceeding has not reached the end of the adjudication when that 60 days notice of likelihood is filed. And this was something raised by the board. What if we didn't get as far as the condition conference? So there's a provision to account for that. Secondly, there is a provision that was added for the constructive approval process to proceed if the presiding officer fails to act within deadlines. We understand that National Grid and Eversource may have a modification to that language that was included. We may suggest some modifications to the modifications, but we'll wait for them to present their comments. So what's next? So as we stated, the siting and permitting program goes into effect on July 1st. That's less than 2 months, but we made it. I will note that some pre-filing activities are already underway. There are a number of agency consultations happening right now. There are interagency meetings happening right now, really helpful. We're coordinating ongoing with DWR to the interaction between the local program and the program that we're establishing. Also, the board is developing training and outreach materials for the new program, but it is coming in a couple of months. I will say that staff really appreciate the opportunity to present these final regulations to the board and are available for questions. Thank you.
All right, we're now going to, are there any questions for Ms. Evans? On the board? Yes? Sure. Commissioner Mahoney.
Yes, I just have to get to them. Okay. These are a couple of questions that may be sort of basic, but just an opportunity to flesh out, I think, what you presented and come from my staff. So they're the smarter ones on this. Okay. If the presiding officer issues a notice of likelihood of constructive approval less than 60 days before the deadline, how can the process under this regulation still move forward? You touched upon that a little towards the end of your presentation.
So the fail-safe provision that we included in the final regulations kind of give a little bit of a grace period to the presiding officer to kind of catch up with the schedule. We didn't want to provide a provision that was so strict that the presiding officer misses 1 day and the whole thing stops. So what we thought would work is give the presiding officer 7 days to catch up, a very definitive time. And then after that time, if the presiding officer still does not act, that the next step in the procedural process, the constructive approval process, would happen. So for instance, the presiding officer didn't issue a notice of likelihood of constructive approval. The next step would be that the applicant would still draft the constructive approval because it's less than 60 days and the process needs to move forward.
Okay, that touches on my next question, so I'll ask it, but I think you've answered, but just in case. If the presiding officer does not issue the notice of likelihood of constructive approval and the board does not reach a timely decision, what is the outcome? Do only the common conditions apply?
So that's an interesting question. I can't imagine that there'd be no constructive approval action whatsoever. That question seems to assume that nothing in 17 is followed. I just don't see that actually happening. But I would assume that the applicant can go ahead and draft the constructive approval, and on the deadline, that's what would become the approved project. Again, the applicant will include in their applications or its application conditions when it files with the board. There'll already be proposed conditions. The applicant's required to attach draft permits with conditions to its application. So those would actually exist already on the record. And so it would be the application plus common conditions. We don't want to get to that point because I think it's much more helpful for the board to issue something that says exactly what applies to this project in a constructive approval. And that's part of what we're trying to put together here.
Then my next question is on the flip side, because there's two sides of everybody is required to do a lot of work on this. If an applicant is delayed in drafting and revising the draft constructive approval, could the application be considered incomplete due to delay under these regs? Could the applicant be considered incomplete due to delay under 980 CMR 13?
So the incomplete, it happens way earlier in the process. It happens the first 30 days of the process. So I don't think that that provision would apply, assuming we didn't get to 90 days. We didn't get to 15 months or 12 months in the first 30 days. So I think the application incomplete issue is addressed much earlier in the proceeding.
I think the answer is no.
Okay, last question. If a notice of likelihood of constructive approval is issued, will the board shift its priorities, or do you recommend the board shift its priorities to the constructive approval process, or will it continue to prioritize the full adjudication of the application?
So there's a provision that makes it very clear that the notice of likelihood of constructive approval does not preclude the board from issuing a final decision. And I think if we got that close, we would want to put resources to try to get to the final decision. So the way this is set up is would basically run concurrently. Those 60 days, the board would be try to get the actual adjudicated decision out. But if it didn't happen, this process is in place to say what happens next.
Thank you. Thank you, Madam Chair.
All right. Any other questions? Commissioner Heupel?
Thank you. Going back to Commissioner Mahoney's previous question, I think it's a good one because understanding that, the time for incompleteness would have passed already by that point in the process. What happens if the applicant, for any number of good or bad reasons, does not draft that constructive approval? Like if there is a world in which the applicant would prefer its initially proposed project to be the one that is constructively approved, whether there's a condition that's been developed throughout the, preceding months of the project that the applicant is not in favor of or otherwise,
and I thank you for the time.
Can you just spell your name for the record, please?
Kristen Mello, KRISTENMELLO. I'm a city councilor at large in the city of Westfield.
Thank you. Thank you very much for your comments and for taking the time today to express them.
Thank you.
Anybody else, public official?
I'll move
Jackie
her into the
Corey.
panel. Oops. Okay. Sir. Yes. Jackie, you're in the panel. If you would like to, or I thought you were in the panel. We'll turn your microphone on so you can speak if you'd like.
Unmute. Yeah. All right. Can you hear me now?
You can. If you could say your
Okay,
name
great.
and spell it for the record, that would be helpful.
Sure. It's Jackie Corey, JACKIE COURY, the select board chair for the town of Blandford. The only thing I wanted to point out was somewhat in line with what the young lady from Westfield had said, but the challenge that we have in reality, you know, when you're really boots on the ground, you're doing this work, is that we are finding that some of these vendors are just trying their best to get through to the end. And if they could pull this out for 12 months, let's say the smaller ones, because we know the larger ones are going to go to the EFSB, they will. And they find ways how do we escalate that so it's known
It's already.
We already got that.
Yep.
Good, excellent. No further discussion online? No? Okay, so let's have a vote.
Chair McDermott,
Yes.
Commissioner Mahoney,
Yes.
Commissioner Heipel,
Aye.
Commissioner O'Shea,
Yes.
Director Gutro,
Yes.
Director Callahan,
Yes.
Mr. Bonfilio,
Yes.
and Secretary Tepper.
Yes,
Motion is approved and the decision is approved.
congratulations, everyone. Thank you.
You wanna-
Can we have a motion to adjourn?
Second?
Have a roll call vote, please.
Okay. We're going to do it again. Sorry. Chair McDermott,
Yes.
Commissioner Mahoney,
Yes.
Commissioner Heipel,
Aye.
Commissioner O'Shea,
Yes.
Director Gutro, Director Callahan,
Yes.
Mr. Bonfilio,
Yes.
Secretary Tepper.
Yes.
We're adjourned.
Thank you.
Thank you. Thank you.
Thank you, interpreters. We are finished.
I think it's fourth in versus identified.
Yes, that fourth is fine.
That's the difference.
Want to make sure. Set forth.